Hi, my name's Gregory Brown, and I'm a business and trial lawyer here in California. And I want to tell you about one of our cases involving a multi-million-dollar real estate dispute. Now, we were hired by the owners of a residential apartment complex in connection with the failure of the buyer to close on their transaction. The purchase price for the apartment complex was $9,240,000, and it had a $500,000 liquidated damages provision for their deposit, which our client kept when they didn't close. Now, in our case, the buyer actually sued us, or our client, for specific performance to force the sale and for breach of contract. The unique aspect of the case was that during escrow, the governor of California signed into law the new rent control regulations, AB 1482, which contained retroactive provisions. At the time, most landlords were not aware that the new law would be retroactive. Now, as part of the deal, the buyer required that our client provide notices of a 7% rent increase to all the tenants and leave the units empty. The buyer argued that the owner should be forced to sell the property at a reduced price of almost $2 million because they were not able to rent or increase the rents due to the retroactivity of the new laws. We argued that there was no provision in the contract allowing for such claim, and certainly no legal precedents supporting this rather bizarre argument. Alternatively, the buyers sought to have the $500,000 deposit, the liquidated damages, returned even though they agreed to this amount, and they were the ones who failed to close on the deal by not tendering the purchase price at closing. Now, for more information on this topic, or if you have any other business or real estate disputes or legal issues, call us today at 714-505-3000 or email us at inquiries@bc-llp.com. Thank you.